Claire, you're not in the will. Dominic didn't look at me when he said it. He slid a folder across the polished table like he was closing a routine business deal. Mr. Patton, the lawyer, sat beside him holding a pen that never touched paper. My chest went tight. $12 million. My name removed like a smudge on glass. I asked Dominic to repeat it. I needed to hear it again. Not because I'd misheard, but because some part of me was still holding on to the possibility that I had. He repeated it. Slower. Colder. The kind of slow designed to make words land twice as hard the second time. My name is Claire Whitaker. I am 34 years old. I spent 3 years sleeping in hospital chairs, learning my father's medication schedule by heart, holding his hand through nights so dark and long they felt permanent. And in about 90 seconds, my brother had erased all of it. I looked at Mr. Patton. He was staring at the table. Not at me. Not at Dominic. Just at the table, his pen still hovering. That was the first moment I understood something was wrong beyond what Dominic was saying out loud. The lawyer's silence was telling me something his words couldn't. Mr. Patton cleared his throat twice before speaking. That nervous sound told me more than anything that followed. There are some documents I haven't fully reviewed, he said quietly. Dominic moved immediately. He pulled the folder to his side, straightened the papers, and looked at Mr. Patton briefly. Then he looked at me. Everything has been finalized, he said. Our father made his wishes clear. Claire was provided for in other ways. Other ways, said with total confidence, as if I'd already agreed to this arrangement. I reached for the folder. I just wanted to see the date, the signature, anything concrete to hold on to. Dominic placed his hand over it. Not violent, not dramatic, just firm and quiet. The way you cover something you don't want examined. Don't make this harder than it needs to be, he said. I looked at Mr. Patton once more. He met my eyes briefly, just 1 second, and in that second I saw something shift behind his expression. Not sympathy exactly. Something more specific. Doubt. He doubted what was happening in this room. And he wasn't going to say, so out loud. Not yet. But he wasn't going to look away and pretend he hadn't noticed it either. I walked out before I broke down. The hallway was long, white, and very quiet. I sat on a bench near the elevator and concentrated on breathing normally. My phone buzzed. Dominic. I let it ring twice before answering. Take what I'm offering, he said. His voice was different now. Quieter. Almost gentle, which somehow felt worse than the coldness. I'm giving you the chance to step away cleanly. Don't embarrass yourself. Offering. As if he was doing me a favor. As if I should be grateful. I said nothing and ended the call. Then a memory surfaced. One that had been sitting quietly at the back of my mind for months, waiting for the right moment to matter. 6 weeks before my father died, in one of his last stretches of real clarity, he had reached for my hand in the hospital bed. His grip was weaker than it used to be, but it was still his. He looked at me carefully and said, if anything feels wrong after I'm gone, check what I signed. Not what they show you. What I actually signed. I had nodded without fully understanding. Standing in that hallway, I finally did. My father's name was Gerald Whitaker. He built his money slowly over 40 years. Commercial properties, careful investments, nothing that needed celebrating in public. He was not a man who required recognition. He just built security, layer by quiet layer. Dominic was 8 years older than me. He had always been the public-facing one. The dinners, the handshakes, the photos. He looked the part of a successful son. He played it well. But when my father got sick, Dominic was consistently unavailable. There was always a reason. A trip. A deal. A meeting that couldn't move. I never said anything about his absences. I just kept showing up. 18 months into the illness, I quit my job as an interior designer and moved into my father's house. I managed his medications, drove him to every appointment, stayed through the nights when his breathing changed in ways that worried me. He was proud and sometimes sharp-tongued and frustrated by his own weakness. But underneath all of that, he was grateful. He said so on the quiet nights. He told me other important things on those nights, too. Including, once, something about keeping something separate. Just in case, he said. Just in case. At the time, I hadn't fully understood what he meant. Dominic allowed me to keep copies of certain documents. I think he believed that was generous. That I'd look them over, find nothing useful, and eventually accept the situation as settled. He had badly misjudged how carefully I'd listened to my father over 3 years. I spread everything across my kitchen table that evening. The will Dominic had presented, the amendments, letters from the estate attorney. I read every line twice. Then I focused on the dates. The updated will, the version removing my name, was dated 14 months before my father died. At first that seemed fine. Plenty of time before his condition worsened. But I had lived beside his medical history. I knew it the way you know a road you drive every single day. 14 months before his death, my father had been placed on a high-dose steroid treatment that severely affected his thinking for nearly 2 months. His own doctor had noted it in writing. I had watched it happen. He repeated conversations. He forgot what day it was. He once called me by my mother's name 3 times in one afternoon, and she had been gone 6 years. The updated will was signed right in the middle of that window. The signature looked right, but the timing was all wrong. Mr. Patton called 4 days later from a number I didn't recognize. Not his office line. That small detail told me exactly how carefully he was moving. His voice was low and measured, a man selecting each word the way you select footing on uncertain ground. "Miss Whitaker, I want to be clear I can't advise you in any official capacity," he said. "But something isn't sitting right with me. Specifically the timeline of the amended document." He had seen it too. "I can't say more than that. I have obligations. But I will say this. Not everything related to your father's estate was necessarily filed with the main will. Sometimes people make separate arrangements. Private ones. Especially when they're worried about complications arising afterward." He paused there. "You may want to look in places that weren't obvious," he said. Then the line went quiet. I sat with the phone in my hand for a long time. Mr. Patton had taken a real risk. He hadn't told me anything directly, but he had pointed clearly at a door. For the first time since the meeting, I didn't feel completely alone in this. My father had done something. He had prepared something somewhere. Dominic hadn't found it. I just had to figure out where. Dominic wasn't waiting for me to figure anything out. He was already moving. Within 2 weeks of the estate meeting, a family friend mentioned the Whitaker property on Coleridge Lane had sold. I went cold. That property had been in our family since I was 7 years old. One of the largest assets my father had ever owned. I called Mr. Farrow, the family accountant for over 20 years. He sounded uncomfortable immediately. "I'm not able to discuss the estate with you directly," he said. "Your brother is acting as sole executor." "Did the Coleridge property sell?" I asked. A pause. Then, "Yes." I asked about 2 more properties, both sold or under contract. Dominic was liquidating everything as quickly as the estate process allowed, converting assets to cash before anything could be questioned, moving with the confidence of a man who believed nothing could stop him. But one small commercial unit, owned by my father for 30 years, required a second signature under its original ownership structure. According to Mr. Farrow, Dominic had proceeded anyway. Without the signature, he had simply moved forward as though the rules didn't apply to him. Because he genuinely believed they didn't, that belief was going to cost him everything. I sat in my car one afternoon and tried to remember every conversation my father had ever had with me about backup plans. Gerald Whitaker was a cautious man by nature. He had grown up with very little and built security one careful layer at a time. He didn't trust single points of failure. He used to say a smart man always keeps something in reserve that nobody else knows about. Then one specific memory surfaced. About 2.5 years before he died, we sat in his kitchen after dinner. He was going through old paperwork. I brought him his tea. He looked up and said, almost casually, "You know I always keep a backup, just in case. A safety deposit box. Not at the main bank. Somewhere quieter." He tapped the side of his nose. Our old signal for something just between us. I hadn't thought about it again until now. A safety deposit box. Somewhere quieter. I didn't know which bank. I didn't know which branch. But I knew one person who might. My father's financial advisor for 12 years was a careful, old-fashioned man named Mr. Aldred, who still kept paper records and met clients in a small office above a dry cleaner's on Pembroke Street. He was my best lead. Mr. Aldred was in his 70s and wore the same brown cardigan every time I'd ever seen him. He had worked with my father since before I was a teenager, the kind of man Gerald Whitaker actually trusted. Not because he was impressive, but because he was discreet. He answered his office door himself and looked at me for a long moment before stepping aside. "I expected you might come," he said. I told him everything. The meeting, the will, the dates that didn't line up, the properties being sold, Mr. Patton's careful phone call. He listened without interrupting, hands folded in his lap. When I finished, he sat quietly for almost a full minute. "Your father was a very thorough man," Mr. Aldred said. "He didn't leave the people he loved to chance." Yes, there was a safety deposit box, established quietly at a private institution called Hartwell Trust 7 years ago. Updated 3 times since then. The most recent update was 8 months before my father's death. My heart rate jumped, but Mr. Aldred held up one hand. "There are specific conditions for accessing it," he said. "It isn't as simple as walking in." He paused. "And your brother was never told Hartwell Trust existed." My father had made a very deliberate decision about that. The access conditions were structured with my father's characteristic precision. The box required a direct family beneficiary present in person, me or Dominic, along with written confirmation from a designated financial contact. Mr. Aldred was that contact. The reason Dominic hadn't found the box was simple. My father never told him. Mr. Aldred confirmed it directly. "It was a conscious decision," he said. "Your father was very deliberate." There was a complication, though. Dominic had flagged all accounts associated with the Whitaker estate through the probate court. Every financial institution receiving a legal inquiry would have to report back. He was monitoring everything he knew about through the estate process. He had covered his bases thoroughly, except for the accounts he didn't know existed. And there was one more detail Mr. Aldred pointed out quietly. The access conditions at Hartwell Trust required a direct family beneficiary to be present. They did not specify which one, and they did not require executor approval. They required my presence. Not Dominic's, only mine. I drove home that evening holding something I hadn't felt in weeks. It was small and fragile and not quite hope yet, but it was the first thing moving in the right direction since Dominic had slid that folder across the table. Dominic called on a Tuesday morning. No greeting. "You've been asking questions," he said. I had tried to be careful, but Dominic had spent decades in business and had connections I hadn't thought to worry about. Someone had talked. I said nothing. "Claire," his tone shifted, measured and almost patient. "I'm going to offer you one final opportunity to resolve this properly. $400,000. A clean gesture of goodwill. You sign a release, the estate closes. Everyone moves forward. 400,000 out of 12 million. I thought about the Coleridge property. I thought about Mr. Patton's careful voice. I thought about my father's hand in mine in that hospital room. "I need time to think," I said. Not a no, just a pause. Dominic seemed to accept it. "Don't take too long," he said. After the call, I sat thinking about his offer. It wasn't generosity. It was a number calculated to feel just barely tempting while leaving him with nearly everything. But more importantly, his tone had changed. He was still composed, still confident on the surface. Something underneath had shifted. A man who is completely certain he has already won does not make offers. He was starting to feel threatened. And threatened people make mistakes. After Dominic's call, I stopped reacting emotionally. I'd been running on grief and shock and anger for weeks, and none of it had moved me forward. I needed to slow everything down and make every step count. A colleague recommended a probate attorney named Ms. Okafor. She was methodical and not impressed by Dominic's name or his confidence. She reviewed my documents, the dated will, my father's medical records from the signing period, my notes from Mr. Aldred, and she didn't hesitate. "We can challenge the amendment on testamentary capacity grounds," she said. "The medical records place the signing inside a documented period of serious cognitive impairment. That carries real weight." She filed the formal challenge within a week. The effect was immediate. Every asset sale within the estate froze. Properties under contract stalled. Buyers were notified. Dominic couldn't move a single thing. Mr. Farrow called quietly to report that Dominic's reaction had not been calm. Good, I thought. Anger makes people sloppy. And while Dominic was furious and distracted, Mr. Aldred called with an update. The conditions for accessing the Hartwell Trust box were nearly met. Just one final confirmation pending. Without planning it that way, I had bought exactly the time I needed. Ms. Okafor found something else buried in the documents Dominic had shared, something I hadn't understood the significance of on my own. My father's original will, the version before the amendment, contained a clause requiring dual confirmation for any major structural change to the estate. Not just a signature, two separate verifications from two different parties, both dated and properly witnessed. The amendment Dominic presented had only one. The second confirmation was missing. Not in the probate record anywhere. Ms. Okafor searched twice. Without the second confirmation, she told me, the amendment may not be legally binding regardless of the signature question. The original will structure may still hold, but proving it conclusively required the original document that established the dual confirmation requirement. According to Mr. Aldred, that document was among the contents of the Hartwell Trust box. Everything kept leading back to the same place. My father hadn't simply hidden something for safekeeping. He had structured things deliberately. The exact proof needed to protect me could only be reached if someone went looking the right way, in the right place, for the right reason. He had built a path carefully. He had left it for me specifically. I just had to reach the end of it. Dominic stopped being careful around week 6 of the challenge. The frozen assets did it. He had planned to move fast and finish before anything could gain real momentum. When the estate hold came through, something in him cracked. Not completely, but enough to show at the edges. He called our father's oldest friend, a retired builder named Mr. Cassidy, and told him I was manipulating the estate out of greed. Mr. Cassidy called me immediately after, sounding unsettled. He seemed very worked up, he said. Not like himself. Dominic also confronted Mr. Patton directly, accusing him of leaking information. Mr. Patton said nothing and documented the exchange carefully. Then Dominic made his most revealing mistake. He contacted one of the estate's creditors and tried to push through a partial disbursement before the hold was fully enforced. The creditor flagged it. Ms. Okafor found it in the court record. Not illegal on its own, but exactly the kind of move that made a judge look more carefully at everything else in the file. Ms. Okafor filed a request to pause all estate distribution pending full review. The judge approved it within 48 hours. For the first time since that first meeting, the momentum had reversed. Dominic had been pushing. Now the system was pushing back. Mr. Aldred called on a Thursday evening. I picked up on the first ring. The conditions are met, he said. We can access the box. I've arranged it with Hartwell Trust for Saturday morning at 9. 2 days away. He told me to bring identification and a copy of my father's death certificate. He would handle the rest. After the call, I wrote everything down in a notebook. The full timeline, every conversation, every document, every date. I didn't know exactly what was in the box, but I wanted to be completely clear-headed when I found out. Then I discovered something that nearly stopped me cold. Dominic had scheduled a final transfer of liquidated funds, cash from the Coleridge sale, and 2 smaller properties for Friday, 1 day before my Saturday appointment. He didn't know about Hartwell Trust. He didn't know about Saturday. But if that transfer went through, millions in cash would move into an account I had no reach over, and recovering it with a court order later could take years. Ms. Okafor moved the moment I called her. She filed an emergency injunction Thursday night. We had 24 hours. I didn't sleep much, but I wasn't afraid. Focus felt better than afraid. The emergency injunction hearing was Friday morning. The courtroom was small, with carpet that smelled like years of difficult conversations. Mr. Hale, Dominic's attorney, argued the fund transfer was a routine executor function within full legal authority. Ms. Okafor placed the medical records from the signing period before the judge. She laid the probate record, showing the missing second confirmation beside it. She presented the full timeline without drama. The judge took 20 minutes. The transfer was paused, but the real crisis arrived that afternoon. Hartwell Trust called Mr. Aldred to flag a complication. Someone had submitted a request, through the estate's probate channels, questioning whether a beneficiary under a contested will had standing to access a private financial asset. The request didn't name Dominic. It didn't need to. My Saturday access was suddenly at risk. Mr. Aldred drove to Hartwell Trust personally. He sat with the branch manager for over an hour and produced a signed letter from my father, written 8 months before his death and formally attached to the box record, specifically naming me as the authorized beneficiary for access. Not the estate, not the executor, me by name. The branch manager read it twice. Saturday still stands, Mr. Aldred told me when he called. My father had even anticipated this. I arrived at Hartwell Trust Saturday morning at 9 o'clock. The building was quiet and small. 2 leather chairs in the lobby. A woman at the front desk who knew Mr. Aldred by name. We were taken to a private room at the back. The box was steel, roughly the size of a shoebox, a reference number along the side. Completely ordinary. I kept staring at it while the paperwork was processed around me. When the branch manager set it in front of me and stepped back, my hands were shaking. I lifted the lid. Inside was one sealed envelope, cream-colored, thick paper, the kind my father always used for important things. My name was written on the front in his handwriting. Not typed, his actual hand. Beneath the envelope lay a smaller document, folded in thirds, with a notary seal on the outside. I picked up the envelope and looked at its date. 14 months before his death. Then I looked at the notary seal on the document beneath. 8 months before he died. 6 months after the disputed amendment. 6 months after the will Dominic had claimed was final. My father had come back here after all of that. He had seen what Dominic was planning, and he had left me an answer before it could happen. My father's handwriting was steady, written during a good stretch, when he was still mostly himself. That steadiness mattered. Nobody could argue diminished capacity against this. He started by saying he was sorry. Not for leaving. He'd made peace with that. He was sorry for what he believed would happen afterward. He wrote that he had watched Dominic for years and noticed specific conversations. Questions about accounts and structures that went too specific to be casual. He had not confronted Dominic. Confrontation would only have accelerated things. Instead, he documented everything. His true intentions, specific dates when he had been pressured to sign documents during his steroid treatment. He named the conversations. He named the requests. He signed each page carefully. Then he described the legally binding directive attached to the letter, prepared by a separate attorney, not Mr. Patton, and registered quietly with a different firm, held in trust until specific conditions were triggered. He had not trusted the main estate process to protect me, so he had built something entirely outside it. A second structure. A second door, built quietly, that only I could open, only if I came looking. He wrote that he hoped I'd never need it. He built it knowing I would. The directive was 4 pages of legal language, but plainly structured once I understood what I was reading. My father had never removed me from the inheritance. He had restructured it. 60% of his estate had been moved into a protected trust that operated completely separately from the main will. It could not be touched by the estate executor. It could not be sold, transferred, or liquidated without my direct written authorization. The trust had been dormant, waiting for its trigger. The trigger, if a named beneficiary contested the main will within 24 months of the grantor's death, the protected trust would automatically activate and transfer control to that beneficiary. By filing the probate challenge with Ms. Okafor, I had triggered it, without even knowing the trust existed. But there was more. A secondary clause addressed any executor who liquidated major estate assets improperly before full settlement. If those actions were later found to constitute misconduct, the assets would be clawed back into the protected trust. Dominic had been aggressively liquidating from the moment probate opened. Every sale, every transfer, every deal he had pushed through while I was still finding my footing. All of it now fell within reach of the clawback provision. He hadn't just lost. He had helped build the mechanism that would undo him. I sat across from Ms. Okafor on Monday morning and placed everything on her desk. The letter, the directive, the notary documents, Mr. Aldred's records, the timeline from beginning to end. She read everything carefully. When she finished, she sat back. "Your father was an exceptionally thorough man," she said. "Yes," I said. "He was." She began preparing the filings immediately. The protected trust documentation went to the probate court with a complete evidentiary package, the medical records, the dates, the missing second confirmation, and the trust directive tying everything together. The court clerk confirmed receipt that afternoon. By end of day, Mr. Patton had been formally notified. His active role was paused pending review. He hadn't done anything wrong. I thought he had probably known something like this was approaching. Dominic's authority as executor was suspended by Tuesday morning. He still didn't fully understand why. His attorney had received the legal notices, but the Hartwell Trust documents hadn't been fully disclosed yet. He knew a filing had been made, He knew his transfers were frozen again. He did not know about the protected trust. He did not know that by liquidating so quickly, so aggressively, he had helped spring the very trap my father had quietly set years before. Ms. Okafor scheduled the formal estate meeting for a Thursday. Same building, same conference room with the polished table, but different now. I arrived early and sat on the opposite side from where I'd been the first time, across from where Dominic had watched me absorb the news of my removal. I arranged my folder and waited. There was nothing left to prove. Everything was already in the court record. Dominic arrived 6 minutes late with Mr. Hale beside him. They took the seats across from me without making eye contact. Dominic looked composed. He had a counterfiling ready. I could see the folder. Mr. Patton sat at the head of the table. Ms. Okafor beside me. Mr. Hale opened by saying the executor's suspension was premature and his client would demonstrate full legal compliance. Ms. Okafor let him finish completely. She was patient the way people are patient when they're holding overwhelming evidence. Then she opened her folder and placed one document in the center of the table. Not the full directive, just the cover page. My father's name. The Hartwell Trust seal. The date that fell 8 months before his death. 6 months after the disputed amendment. Dominic looked at it. Something in his face went completely still. Mr. Hale picked up the document and read carefully. Dominic watched his attorney's face the way you watch a weather forecast when you already sense the storm is overhead, searching for any sign the damage was smaller than it appeared. Mr. Hale's expression gave him nothing. This document was registered with Aldred and Crane solicitors, he asked carefully. Correct, Ms. Okafor said. And last updated 8 months before Mr. Whitaker's death. Dominic sat very still. Mr. Hale turned to the second page, the page describing the protected trust structure and the percentage held within it. 60% of the total estate. I watched Dominic's hands, flat on the table, the way he always placed them when he wanted to project calm and control. But his jaw was tight. He turned to the second page himself. Then he looked up at me. I had seen many versions of my brother's face over 34 years. Confident, dismissive, satisfied, impatient. I had never once seen what I saw at that moment. Genuine, unguarded uncertainty. Not guilt yet. Not shame. Just the expression of a man whose calculation has come back wrong and who cannot immediately locate the error. He said it quietly, almost to himself. This isn't possible. Ms. Okafor placed the next page on the table without a word. Ms. Okafor read the directive aloud. Not all of it, just the provisions that mattered most for that room, on that day. The protected trust clause, the trigger condition, the asset clawback provision. She read everything in the same steady tone she used for every document. No added drama. The words carried their own weight. Dominic's attorney tried 3 angles as she went. He questioned the registration process. He suggested the trust might not supersede the contested will. He challenged whether the trigger clause had been properly activated under current probate law. Ms. Okafor answered each objection without raising her voice. Every challenge had a documented answer because my father had anticipated every challenge. He had spent decades in business. He understood exactly how someone would try to dismantle what he left behind. The clawback provision was when Dominic's composure finally broke. Ms. Okafor read it plainly. Any executor who liquidated major estate assets prior to full settlement in a manner found to constitute improper conduct would be subject to recovery of those assets into the protected trust. The Coleridge property, the commercial units, the transferred funds, all within reach. Dominic pushed back slightly from the table. He looked at Mr. Hale. Mr. Hale was still reading. Legally, completely, the ground had shifted under everything Dominic had built. The final clause was what my father called the accountability provision when describing it to Mr. Aldred during the drafting. It stated clearly that any party found to have deliberately manipulated the primary estate, particularly through pressure applied during a documented period of cognitive vulnerability, would forfeit their share of the protected trust entirely. Not reduced. Forfeited. Dominic's share, which would have been 40% of the protected trust under the original structure, became subject to that clause the moment the probate court confirmed the amendment was signed during the medicated period. That confirmation came the following week, supported by the medical records and testimony from my father's treating doctor. Dominic lost the protected trust share completely. What remained was his portion of the main will assets, substantially reduced by the clawback of improperly liquidated properties and further diminished by legal costs. He filed a notice of intent to appeal. His right, but the documentation was overwhelming. Mr. Aldred, Mr. Patton, the medical records, the notarized directive, every date aligned exactly. Both appeals failed. At the final estate review, Dominic sat across the same polished table where he had once slid a folder and told me I had no right to anything. He said nothing. I said nothing. My father had already said everything that mattered. I walked out of the final meeting into cold, clean air and stood on the pavement for a moment. No confrontation. No scene. None of that had been necessary because none of it would have changed a single legal outcome. My father had understood something I had to learn the hard way. Emotional confrontations feel powerful in the moment. Quiet preparation changes everything. The estate settled over the following months. The protected trust transferred to my control. The clawback recovered the majority of the liquidated property value. Legal fees were covered within the directive's own provisions. Mr. Patton was cleared. Mr. Aldred retired that spring. Dominic stopped making contact after his second appeal failed. I sold the family house eventually. Not for financial reasons. I simply needed to stop living inside the geography of everything that had happened. I bought a smaller place and returned to design work. Some days I still hear my father's voice from that hospital room. Check what I signed. Not what they show you. What I actually signed. He had known what Dominic might attempt. He had seen it years before the end and answered it quietly without anyone knowing. He didn't give me a fight. He gave me a path. And he made certain I was the one holding the pen all along.